Thank you very much. The recording is going. Then also um, during the presentation, we will not allow any questions. So we'll first allow a speaker to do our presentation. But obviously you may have some questions or comments. May I please request that you either just write it down on a notepad in front of you, or you can use the chat box here on the right-hand side at the bottom. And as we proceed, you can post your questions or comments there. Then after the presentation, I will go back to those and see if there's any questions, and we will then have a QA session and then have a nice bit of a chat through some of the things that you might want to know a little bit more. So, yes, so it's for me a privilege to introduce Mr. Henry Jacobs this evening. Maybe just a short brief. Besides the fact that he is also an academic and making some contributions in the world of academics, he is also a practicing attorney, which with a quite impressive track record, specifically in the CCMA. And that's why the reason I have asked him to come and share with us, as we have a person with years of experience in the real world out there, dealing with disciplinary matters on various levels, various organizations. And we're looking forward to a nice practical insight. And I'm pretty sure many of you will definitely benefit. And also, I believe it will definitely assist you in understanding the subject, then labor relations, a little bit more in detail. So, Henry, thank you very much. I'm going to pass over to you there, and I'm just going to mute my mic and cameras and allow you the opportunity. So, ladies and gentlemen, as I said, just write down your questions or use the chat box. And then after the presentation, we will look at those questions and we will respond to them. Henry, over to you.
Thank you, Mr. De Jager. Thank you very much for the opportunity tonight to come and talk about disciplinary matters in the workplace. Yes, as Mr. De Jager said, I am a practicing attorney specializing in labor matters. I have been to the CCMA and to the labor court and to bargaining councils more times than I would care to admit. But that is the nature of our jobs. That is the nature of HR and IR at the end of the day. So that is what we do. When something happens, and especially when it comes to disciplinary matters, we then have to proceed to the CCMA and the bargaining councils and labor court at the end of the day if stuff doesn't go right. And that is probably the main thing why we have this seminar or the webinar in terms of disciplinary matters tonight, is to ensure that when we get to the CCMA or when we get to the bargaining council, that everything that we have done in terms of procedure and substantive has been correct, and that we do not have to settle or whatever the case may be when it comes to the troubles that or disputes that have been arose. So just jumping into the whole disciplinary matter and disciplinary in the workplace thing, the first thing that we need to discuss, or the first thing that we need to look at, is the question of what is discipline in the workplace. So how do we look at discipline in the workplace, and how does it compare to the normal day-to-day dealings in the workplace that we do? So looking at it, a disciplinary action or discipline in the workplace will be appropriate where a breach of the rule cannot be condoned or where counseling has failed to achieve the desired effect. So that is, in a nutshell, what a disciplinary action is. So when we take that back in order to determine what discipline in the workplace then actually is that we now have, when we talk about a disciplinary action, we have a set of rules that need to be followed in the workplace in order for the company to work effectively. All right, not just for the company to work effectively, but to promote a harmonious dealings and with the employees towards other employees, employees towards the employees in this whole system. So in the event that those rules are not complied with, that is where the employer or the company can proceed with disciplinary action. So if the rules are broken, a disciplinary action may follow. So considering that, where are these rules contained? So where do we get the rules that determine right and wrong in the workplace? So the main place where we can find these rules in terms of what is right and wrong in a workplace setting is the workplace code of conduct. Now, as we already said, a code of conduct includes policies and rules for employees and employers to follow in the workplace. So it regulates the conduct on how employers should deal with their employees in a certain way, and further, which is the most important part, is how employees should conduct themselves in a workplace setting. Often, a company uses its core values, including its mission, or guide the creation of these codes. These guidelines outline how people can appropriately interact with one another at work. One of the things that we need to remember when a code of conduct is developed at the end of the day, it is not necessarily based on law, on the Labor Relations Act, on the Basic Conditions of Employment Act, on Employment Equity Act. Most of the time, it relates to the core values that a company has and the core values that they want to ensue into their workplace and onto their employees. Some of these rules, in terms of a code of conduct, is is based on legality. For example, in terms of Employment Equity Act, in terms of discrimination and all those type of really things that we need to determine and what we need to set out when it comes to workplace conduct. But sometimes, and in most cases, a code of conduct is developed through the core values of the company. Continuing with that, the purpose of a disciplinary code is to regulate standards of conduct of employees within a company or organization. The aim of a workplace disciplinary code is to provide mechanisms to correct unacceptable behavior and to create certainty and consistency in the application of discipline. Disciplinary procedures need to be fair. Disciplinary procedures may also be included in a collective agreement. Now, just taking that purpose of the disciplinary code at the end of the day, it is designed to provide the company as well as the employees with the rules on how to conduct themselves. Also, combined with that, with the rules, is also what would happen to that employee in the event that employee does not comply with the code of conduct. Now, I put an example for you guys on here. So this is a normal disciplinary code that we 99% of the times where we are asked to draft a disciplinary code, this is the disciplinary code that we use. So first of all, we have a nature of offense. So that would be the rule, what the rule is about and how the rule is structured. In this case, it is absent from work without notification for 1 to 3 days. So the explanation that we provide is the explanation that what is this rule about? So in terms of this rule, it refers to being absent from work without prior notification or permission and without a valid reason. So what we like to do is provide the employer and the employee with an explanation. So we have our rule and the explanation regarding that rule so that that person can no longer say that they were unaware or they did not know what was meant by that rule. So this gives everyone a clear understanding about what is expected from them and how these rules are to be implemented. All right. Further to that, we also have a first offense, second offense, and third offense. So normally, when it comes to minor situations, minor offenses, we always give the employees a first offense, a second offense, and even a third offense. So in this case, the first offense will be a written or a final written warning, depending on the severity of the conduct in the circumstance. In a second offense, it can lead to a dismissal. Those are the actions that the employer is allowed to take when it comes to the disregarding of this particular rule. Right. Further, you can see there's absent from work for more than 4 days and also desertion of post or site. So that is, at the end of the day, just a normal structure in terms of a disciplinary code that we normally use in practice. So what will happen is when the employee signs their employment contract, they are provided with a disciplinary code. So they need to know, in terms of the disciplinary code, what is expected of them. In most companies, the law has required companies now to put a disciplinary code where the employees are regularly based. So, for example, in a chill area or whatever the case may be, where they can regularly see that. I'm going to explain to you why this is important a little bit later. But at the end of the day, this is just a disciplinary code at the end of the day that we look to. Right. So now we've got our disciplinary code and we know what is expected of us. And now we get an employee who has broken one of these rules in terms of the code of conduct. So what is the employer to do? What can the employer do at the end of the day? So firstly, we will have to determine the difference between counseling and a disciplinary hearing. So in most cases in practice, when it comes to counseling and disciplinary hearings, we as the employer firstly have to counsel this employee, tell this employee, like, listen, this is what you have done wrong. Let us rectify that behavior and then see where we go. If that behavior then continues, then we go to disciplinary hearing. And in some cases, it does happen where a counseling will be more helpful than a disciplinary hearing at the end of the day, because it depends on the severity of the transgression at the end of the day. So I had a disciplinary hearing during the week, and the employer wanted to fire the employee, but the employee has done everything that they were supposed to do, and they rectified their behavior. So because of that, we recommended rather go with counseling. Counsel that employee, tell them, like, this is where you've gone wrong. Why is this important? Because when it comes to a disciplinary hearing and that employee gets dismissed and that employee decides, like, listen, I feel that this was an unfair dismissal, and based on that, I'm going to go to the CCMA. I'm going to declare a dispute at the CCMA. Now we have to go to the CCMA. We have to go argue our situation. If the employer did not do everything in their power, for example, did the counseling, gave a warning, or if the sanction can be a written warning, a dismissal, whatever the case may be, if that sanction is too hard at the end of the day, the CCMA will find in favor of the employee. But now, looking at the difference between counseling and a disciplinary hearing, there's a difference between disciplinary action and counseling. Counseling will be appropriate where the employee is not performing to the required standard or is not aware of a rule regulating conduct or where the breach of the rule is relatively minor and can be condoned. When it comes to disciplinary action, it will be appropriate where a breach of the rule cannot be condoned. So when we look back at counseling, this is where we can, okay, it was a minor transgression. For example, this employee has come late to work. We have to now talk to that employee to say, like, listen, you can't come late to work. It is an issue because it affects the business and it affects morale. It affects the other employees. So therefore, we rectify it. We have to talk to that, counsel that employee to rectify the behavior. Now it comes to a transgression where the breach of that transgression cannot be condoned. For example, we had a few instances where an employee was caught smoking on the premises of a petrol garage. So he was smoking near the petrol tanks. So that can be a potential life-threatening conduct. Now, because of that, we cannot condone the breach of that transgression, and therefore we can then proceed to a disciplinary hearing, disciplinary action, where, as we said, it will be appropriate where a breach of the rule cannot be condoned or where counseling has failed to achieve the desired effect. Okay, even after we've counseled the employee and the employee has continued to act in a certain way, we are allowed to then proceed with disciplinary action. So before deciding on the form of discipline, management must meet the employee in order to explain the nature of the rule he or she alleged to have breached. The employee should also be given the opportunity to respond and explain their conduct. So now we have a transgression that has been, it's not condoned by the company. But in order for this whole thing to eventually then come to fruition, we now have to then proceed with a disciplinary hearing. A disciplinary hearing is set at the end of the day in order for the employer to provide evidence against that employee and for the employee then to respond and explain their conduct. That is one of the most important things when it comes to a disciplinary hearing, which I will show you guys, is the fact that we have to give that employee an opportunity to state his case, to state why he has done what he has done in front of a neutral chairperson. So continuing with that, we can now look at the disciplinary procedure. So what is the disciplinary procedure at the end of the day? So disciplinary procedure, all right, a disciplinary hearing, as we just said, that transgression, that breach of the code of conduct at the end of the day has led to a procedure, to a hearing, in this case disciplinary hearing, where the employee is supposed to give their side of the story and the employer provides evidence to a neutral chairperson when it comes to decide whether or not what action or sanction should be taken. So a disciplinary hearing is an internal process where substantive and procedural fairness must be applied in all cases. The employer bears the burden of proof to establish guilt, although the rules applied in a court of law and the rules for a disciplinary hearing are not the same, but there are similarities. So for example, in terms of a court of law, you have your judge, you have your applicant or the state, and you have your respondent or your defendant, and that is the process. That's the triangle. Disciplinary hearing is exactly the same. We have a chairperson who makes the decision or provides a recommendation to the employer. We've got the employer, who is the accusing party. So for example, they will be, in this case, the state, if we talk in the court of law. And we then also have our accused, the accused employee. All right, that will be then the employee who transgressed. All right, so that is the triangle. With that also comes leading of evidence, leading of witnesses. You are you're allowed to cross-examine, ask leading questions, all those type of things in a normal disciplinary process. So normally when we are in a disciplinary hearing and I am the chairperson in a disciplinary hearing, I explain the whole purpose and the whole process of the disciplinary hearing to the employee and the employer. So I would say that if the employee pleads not guilty, then we are going to proceed with the whole process of disciplinary inquiry, starting with the opening statements by the employer and opening statements by the employee. Thereafter, we are going to lead evidence. Firstly, the employer will provide us with their evidence. In that, the employee will have an opportunity to question that evidence. Thereafter, the employee will provide their evidence. The employer will have an opportunity to question that evidence. Thereafter, closing statements will be made. And then we also talk about mitigating and aggravating factors. Mitigating factors will be the factors that the employee is going to tell the chairperson why they should not lay a sanction on that employee. Aggravating factors are the factors that the employer will tell the chairperson on why the sanctions should be imposed on that employee. And that is normally the process of a disciplinary hearing that we take. So when we come to a disciplinary hearing, what is the first step that we look at? How are we going to start this whole procedure? We start the whole procedure with a notice of disciplinary inquiry. So within this notice, this is one of the most important notices because this starts the whole procedure. The thing about this is if we do not start with a procedure or the correct procedure, then when we get to the CCMA will always look to two things: whether or not there was substantive fairness, whether or not there was procedural fairness. The notice of disciplinary inquiry is the main or the first start of the procedural aspect of our case. Once we have dealt with that and we ensure that a proper procedural disciplinary inquiry has been done, then all we have to argue is substantive, and that is then fine when we go to the CCMA. Okay, so looking at a notice of disciplinary inquiry, at the end of the day, it's very important for us to put in the name and the surname of the employee. Right, thereafter, the date and time of the hearing, which is very important, when that hearing will run. Thereafter, it will be whether or not that employee will be on suspension, pending an investigation, or not. Now, what is the effect of this? Why would we put someone on suspension when we have to, for example, investigate a matter further before we proceed with that disciplinary inquiry? So the fact is that when we have to put someone on suspension pending an investigation, that is in order for the company to do a proper investigation without undue influence by that accused employee. So it does sometimes happen that there's money involved in, for example, stealing or something like that, where we have to remove that employee from the situation in order to do an effective investigation. Can be also where that employee will be influencing other employees from coming forward, or at the end of the day becoming witnesses to testify against that employee, so that there's no due influence on any potential witness in the company. All right, thereafter, if the suspension and everything has then been concluded, we have to put out the employee's rights. So what rights does this employee have in terms of this disciplinary hearing? So according to this, the employee has a right to a representative from their place of work. They have the right to state their case. They have the right to lead witnesses. They have the right to question the employer's witnesses. They have the right to appeal the matter, and they have a right to refer this matter for arbitration. So these are normally the rights that every employee has when it comes to a disciplinary inquiry. It is very important because these rights, if one of these rights are not adhered to, it can lead to a procedural defect, and we will then hurt when it comes to the CCMA. The CCMA will make us pay when we don't follow our procedure at the end of the day. Okay. So after that, we give the transgression, because we have to inform the employee at the end of the day, why are we putting him on notice of disciplinary inquiry? What has he done? In this case, it was gross negligence, as this person has targets that he did not meet, and therefore we have to proceed after counseling, after warnings, after final written warning. We are now proceeding with a disciplinary inquiry to get a third neutral chairperson to come in and recommend a specific sanction for us. All right. So this is a basic notice of disciplinary inquiry, the importance of it at the end of the day, one of the most important things that we have to remember when it comes to a notice of disciplinary inquiry. We have to give that employee at least 48 hours time to prepare his case before the hearing can commence. Okay. So now we have started. We have the notice of disciplinary inquiry. It has been provided. It has been sent to that employee. He has accepted the notice. He has signed for that notice, showing that there is proof he received the notice in due time. So now comes our next question is, when can an employer hold a hearing? So, just as I said, in terms of the disciplinary notice, an inquiry should be held as soon as reasonably possible after the employer becomes aware of the alleged disciplinary offense. An employee may be suspended on full pay pending a hearing, especially in instances where the employee's presence may jeopardize an investigation or constitute a threat to the health and safety of other employees or to the assets of the employer. The employer should give the employee not less than 48 hours notice of the inquiry, and a letter should include the date, time, and venue of the hearing, details of the charges against the employee, and the employee's rights, including the right of representation at the hearing by either a fellow employee or a shop steward. So we are going to look at that a little bit later in order for us, the representation part. So in most instances, when we get to a disciplinary hearing is an internal process. So it is very, very seldom that an employer or a company would allow an employee to come with external representation. For example, bring their lawyer, bring their uncle, bring their dog if they wish to, for moral support. It does not happen at the end of the day that we would allow external representation to come into the disciplinary hearing, because it's an internal process. So now we have to talk about unions. We're going to talk about unions a little bit later as well. When we talk about unions always have an issue with that process, because they feel that they have to represent their members. That is why we have shop stewards. So the shop stewards, as representatives of the union, are allowed to represent the employees, but not outside union representation. All right. So when we look at it, if the employer also intends to discipline a shop steward, so now we've got also have to distinguish between a normal employee and a shop steward. Now, as we said, a shop steward is a union representative in the company. He works for the company, but he has duties. For example, if you are an AMCU representative, you are a shop steward in a company representing AMCU. So the minute that a company wants to proceed with disciplinary action against an employee who is a union member, they first have to consult with the union before that disciplinary inquiry notice is sent out, to tell them, well, this at the end of the day, this is what we want to do. This is how we are going to proceed. We want to take disciplinary action against your shop steward. And then the union will go to that shop steward, discuss everything, and the union will then be allowed to represent that shop steward. That is the only time that external representation will be allowed, is when it is a shop steward of a union. All right. I hope you are still with me and that you're not getting too bombarded with too much information at the end of the day. But yeah, so that is unions at the end of the day. So now we've got a hearing. We know why we are doing the hearing at the end of the day, for that breach or that transgression of the code of conduct. So the next thing that we have to look at is who should be present at a hearing. Who should be there when it comes to the disciplinary hearing? First of all, a chairperson. A chairperson is a neutral third party. Most of the time, if you are going to go into labor law at the end of the day, it will happen that you will become a chairperson at one stage of your career. Now, a chairperson is a neutral third party who listens to both sides, either the employer and the employee sides, and then recommends a sanction to the employer. One thing that you guys have to remember is that a chairperson only recommends. They are not allowed to put in a sanction. All right, they are not the judge. It will still be the final decision of the company at the end of the day. Now, clue at the chairperson, there will also be a management representative. So a representative from the employer side, the employee, the accused employee, the employee's representative, if there is required to be one, any witnesses for either party, and also an interpreter if required by the employee. The interpretation is a right that employee has. The employee has a right to interpretation. If it is a language that they do not understand, then they are entitled to an interpreter. Then, how should a hearing be conducted? So how should this thing run at the end of the day? So I already explained to you guys what happens when we walk in. I go through all of the documentation with them. We call it a report, disciplinary inquiry report, and it has questions on it. For example, was the purpose explained to the employee? All right, so that is where we explain you plead guilty. If you plead guilty, this is how the process runs. If you plead not guilty, this is how the process runs. But the one thing that we talk about disciplinary hearing is that the hearing does not need to be formal. We don't have to go with suits and everything, have dockets and files and everything. It can be an informal procedure. So there's also not someone who is going to cascade you if you ask questions out of turn and all those type of things. That would be for the chairperson at the end of the day to lead this disciplinary inquiry to get the information that they need. So the employer should lead evidence related to the allegations, and the employee is then given an opportunity to respond. The chairperson may ask any witness questions for clarification. Once both versions have been heard, the chairperson decides whether, on a balance of probability, the employee has committed the misconduct as alleged. If misconduct is established, the chairperson may ask both parties to make submissions on the appropriate disciplinary sanction. The chairperson must then decide what disciplinary sanction to impose and inform the employee accordingly. All right. Then, if the employee fails to attend the hearing without good cause, the hearing may continue in the absence of the employee. I've also done one of those this week. So during that, what I normally do if I am a chairperson and the accused employee doesn't show up is that I give that employee a call. If that employee doesn't pick up, then I continue with the hearing. So then I base everything that I have. First of all, the employer has to prove that they have given enough notice to that employee to know that that employee should be there. All right. After that, if I'm satisfied with what they've provided, to know that they have done everything in their power to inform this employee about their disciplinary hearing, then we proceed in the absence, in absentia, as it says in the law. All right. So then, where a disciplinary procedure is prescribed by a collective agreement. Remember, a collective agreement is an agreement signed by either a union and the employer or a bargaining council, which an employer belongs to. So, or in terms of a policy or conduct of the employment, this should be followed unless justifiable and fair reasons exist to deviate in some way from this. Parties can also request by mutual consent the CCMA or bargaining council to appoint an arbitrator to conduct a final and binding disciplinary inquiry. So then we get to item 4 of the Code of Good Practice, which is a dismissal. Schedule 8 of the Labor Relations Act sets out the minimum standard of a procedural fairness that is required. So when we look at it, what is a form of discipline when it comes to a disciplinary hearing? First of all, disciplinary action can take a number of forms depending on the seriousness of the offense and whether the employee has breached the particular rule before. Following forms of discipline can be used. So what we normally do, and that is where the disciplinary code comes in, which is extremely important for us, because that can determine if it is a first offense, what should we do? What is the appropriate sanction in a first offense? Then we go to second offense. What is the appropriate sanction in the second offense? So when we talk about coming late, for example, it is a minor transgression. So when we get to it, appropriate sanction would first of all be a verbal warning. Thereafter, second offense may be a written warning. Third offense may be a final written warning, depending on what it can be. Fourth offense can be a dismissal at the end of the day. So these are forms of discipline. So we looked at verbal warnings, written warnings, final written warnings, suspensions without pay for limited periods, demotion as an alternative dismissal only, or a dismissal. One thing that we have to note about demotion at the end of the day is that demotion can only be applied as a sanction if it has been agreed to by the employee. So it has to be stated in the disciplinary code that demotion is a sanction. Otherwise, we're not allowed to demote the employee. Okay. So then, further to that, we also have something called progressive discipline. So progressive discipline is a system all employers should adopt in the workplace and refer to the gradual process taking place in stages. That is also why we have our disciplinary code, where we have our offenses, and we have first offense, second offense, third offense, fourth offense. That is what progressive discipline is. So, if it is in the terms for a minor transgression, the courts have endorsed the concept of corrective or progressive discipline. So that is where we talk to them, we counsel them, we provide them an opportunity to actually get better, to do their job as they were supposed to do. Final written warnings, normal written warnings at the end of the day. It goes in stages, progressive discipline at the end of the day. So this system of escalating responses to misconduct by the employer, and which is intended to correct the behavior of the employee. We are, in terms of progressive discipline, trying to correct the behavior of that employee. It is only at a stage where we cannot correct this behavior anymore, where we then proceed with the disciplinary inquiry, and then that may lead to a dismissal. Right, so the stages of progressive or corrective discipline is first of all a verbal warning, then a written warning, a suspension, and then at the end of the day, termination, if the chairperson agrees or recommends termination, dismissal of the employee. Okay, so quick minor infractions may include absence without leave, failure to inform the employer of your absence and expected date of return, reporting late for duty, leaving the workplace earlier or deserting the workstation, failure to return to work timelessly after lunch. The thing that we have to remember with minor transgressions and even major transgressions is that it is not a limited list. There's no list that says these are the transgressions, and if they are broken, this is what we are doing. All right. These transgressions can be unlimited. There are so many transgressions that can actually be combined into minor infractions and even major infractions. The fact is, the company's morals, the company's values, the company's ethics, all of these things are going to play into their disciplinary code. So it might happen that in some instances or some companies, they have a stricter ethical behavior. For example, when you talk about money or forensic auditing, they will have a stricter disciplinary code where someone in, for example, sales will have something completely different. Their code of conducts will not be the same, although they might have correlation with each other. It depends on the ethics of the company itself. Then major or serious misconduct may include dishonesty, willful damage to the property of the employer, willfully endangering the safety of others, physical assault, gross insubordination. One thing that we have to remember is that each case should, however, be judged on its own merits. That is where substantive fairness comes in. We have to look at all the circumstances relating to that transgression, and that is how we then proceed with our sanctions and our disciplinary inquiry. So just then, I wanted to talk about the substantive and procedural fairness very quickly. So the onus of proof at the end of the day, the matter of fairness. So who bears the onus in what circumstances? So when we look at substantive fairness are the merits, what actually happened, the actions, what occurred, what transgression occurred at the end of the day, what rule was broken in terms of the code of conduct. So substantive fairness looks at the consequences of an employer's misconduct in the workplace. Procedural fairness is what did we do? It relates to the addressing the misconduct committed, a disciplinary hearing, or the issuing of a warning. So that will be our corrective measure. What is the process that we followed in order to correct the problem, the substantive matter, what we have to do now? So the burden of proof at the end of the day, first of all, in terms of procedural fairness, a dismissal will be considered procedurally fair if it is done according to the process provided for by the Labour Relations Act. An investigation must be conducted by the employer into any alleged misconduct. An opportunity must be given to an employee against whom an allegation of misconduct is made to respond thereto. So that is the procedure. We have to follow procedure. We have to issue them with a notice of disciplinary inquiry. We have to give them 48 hours to prepare for the matter. We have to provide them with an opportunity to bring a representative from their place of work. We have to give them an opportunity to state their case. We have to give them an opportunity to provide us with mitigating circumstances. Those are all procedural aspects. If we do not follow those procedural aspects, when we get to the CCMA, they are going to make us pay. So that is why procedure is extremely important. Then when it comes to substantive fairness, those are the merits. Those are the actual, what happened. And that can be one of three things. Substantive fairness will only be if there was a misconduct by the employee, incapacity of the employee, or operational reasons. But as we are looking only at disciplinary hearings today, we are looking at misconduct most of the time. But when we get to substantive fairness, misconduct, incapacity, or operational reasons are the three substantively fair reasons why we can dismiss an employee. So dismissal for misconduct, if we at the end of the day have to dismiss that employee, first of all, the workplace misconduct is an improper employee behavior that's inappropriate for the workplace and negatively impacts their work. Where do we find our misconduct? In our code of conduct. So if there was an improper employee behavior that broke one of those codes or has transgressed a rule by the company, then we can dismiss them based on misconduct. So in terms of substantive fairness, there's always 5 questions that we need to answer. If we go to the CCMA, they will also, all our arguments will be based on these 5 questions. First of all, did the employee contravene a rule or standard regulating conduct in all the relevance to the workplace? So did that person break the rule? If yes, if that person broke the rule, then we have to determine, was it a valid or a reasonable rule? All right, I always say when I have a drug dealing empire, I am a drug lord and I provide my little drug dealers underneath, provide them with employee contracts. They have everything in terms of it's perfect. Now, he breaks the rule by selling drugs for more than I want him to sell it for. Is it a valid and reasonable instruction from the employer to tell that employee to sell drugs at a certain price? No, it is illegal. And therefore, in terms of substantive fairness, it is not fair. But if it is a reasonable instruction, a reasonable rule, then we can say we are allowed to dismiss that person on misconduct. Third question that we need to answer is, was the employee aware of the rule, or could he or she reasonably be expected to have been aware of the rule? That is why nowadays it is very important for a company to put where the employees can reasonably see, or at most of the time see, these the code of conduct and also the basic conditions of employment act, so that they know what is expected of them, and in the employer side they can know that they can't turn around and say, like, I didn't know what I was supposed to do. That they knew what the rule is, or reasonably ought to have known what the rule was. And the fourth question that we need to answer is, did the employer constantly apply the rule? So here's the thing. A good example is if the employee comes late. So Jenna that comes late every 2 weeks, she just gets, oh, hi, Jenna, please don't come late. And now you come late as an employee and already you get a final written warning. So it is very important for the employer to consistently apply the rules of the company in order to ensure that substantive fairness are there. And then if a dismissal is an appropriate action for the contravention of the rule. That is, again, where we took a look at progressive discipline. Is it, at the end of the day, dismissal the final thing that we can do? If we answer those 5 questions in the positive, then we have substantive fairness and we can dismiss that employee fairly. All right. Just quickly, further to that, I'm going to run through this because I see we don't have a lot of time left. So unauthorized absence from work, we've already talked about that. The principle is the primary responsibility of the employee is to make their services available to their employer. If they don't do that, we can then proceed with a action against them. Remember, progressive discipline, so absent from work, first offense, second offense, third offense, third offense. Verbal warning, written warning, final written warning, and then dismissal. Then substantive fairness, in terms of attitudes of hostility, abusive language, racism, and insubordination. The employer may expect an employee to work together in a reasonable, harmonious relationship. If not, if there is something that comes out which is abusive towards any employee or a manager or whatever the case may be, that person can be put on disciplinary hearing. Then also, when it comes to theft, team misconduct, dishonesty, those are considered to be very serious misconducts. So theft, maybe an employee causes irreparable harm to the trust relationship of trust and confidence between the employer and employee. One thing that I quickly want to tell you guys about theft is that I've read cases where, in some circumstances, the employee stole a piece of bread. So she was a waiter at a deli, and she took the plate after the customer was finished. She took the plate to the kitchen, and she took the bread that was left and she ate it. She got dismissed because of that. The CCMA, the labor court, said that you're not allowed to dismiss that because the sanction of dismissal was too harsh. But in other circumstances, the guy stole a metal rod. The metal rod has an economic impact on the company, and therefore dismissal was fair. So even in terms of theft, we will have to look at progressive discipline, whether or not a dismissal will be the correct sanction for the circumstance. Then other types of misconduct include assault, conflict of interest, damage to property, intimidation, sexual assault, and even alcohol and drug abuse. So procedural fairness is, as we have discussed it, all the actions what the employee has to take. This is just that the employee get reasonable time to prepare. Was the employee allowed to state their case? Did the employer, after the employee communicated the decision taken and finished the employee with that decision? Those are still form part of the procedure. We have to let that employee know, like, listen, this is the issue, and that is why you have been dismissed. Both substantive and procedural fairness are required for a fair dismissal. It's not either or. Both of them have to be there in order for a fair dismissal to be present. Then what is a dismissal? Dismissal takes place when the contract is terminated at the instance of the employer by some act which denotes that the employer has brought the contract to an end. That is regulated by section 186 of the Labor Relations Act, and it includes these 6 items: termination of the contract of the employer with or without notice, refusal to extend a fixed term contract, refusal to allow the employee to return back to work after she took maternity leave, selective re-employment, constructive dismissal, and employee being provided with less favorable terms after a Section 197 takeover. This is just how a disciplinary inquiry works if after a dispute has been lodged with the CCMA. So first of all, a dispute has to be lodged within 30 days. Thereafter, we have 2 processes: conciliation and arbitration. Conciliation, if it's successful, the matter is settled. If we have to go to arbitration, that is where we have to fight at the end of the day. All right. I've run through the dismissals quite quickly. If you have any questions, please ask me. But that, ladies and gentlemen, concludes the section of disciplinary hearings or disciplinary actions. Is there any questions that I can answer for you? Mr. De Jager.
Thank you very much, Henry, and thank you for your very nice, straightforward, very practical, very clear presentation, I think, on the whole process of dismissal. And I know from my own experience that many employees, are not really aware of, all these procedures and ways and things that must happen. And I also I think our students will definitely benefit from having a very clear, concise, straightforward message on the issues of dismissal. So from my side, thank you for that. Ladies and gentlemen, so let me allow opportunity. Geraldine said, seems like she liked the session there. Thanks, Geraldine. There's no questions in the chat box. Ladies and gentlemen, is there anybody that have a question? You can just open your mic there. Shane, you can go ahead.
Hi, I wanted to just find out when it comes to the bargaining council and contracts, because now I think it's a bit related to constructive dismissal. For example, if your employment contract versus an alleged bargaining council agreement doesn't go hand in hand, is that legal?
It depends whether or not the company is a member of a bargaining council. So in some circumstances, a company is or should be part of that bargaining council. In terms of the bargaining council's collective agreement will only provide a certain standard of employment contract. So the employer is not entitled to give lesser benefits than the collective agreement by for example, the MEIBC, then the bargaining council. They can always give more. So the contract can vary to some extent when it comes to the bargaining council's collective agreement and the employment contract. One thing that we have to remember is that a collective agreement will always trump a employment contract or the Basic Conditions of Employment Act if it is better than the basic conditions of employment. So when it comes to then a dismissal or the procedural aspects of a disciplinary inquiry, we have to follow, if we are bound by that bargaining council, we have to follow what is in that bargaining council's disciplinary code or procedure on what we should do.
But the bargaining council's agreement wouldn't be lawful to be in, for example, it shouldn't be out of what the basic conditions of employment states, right?
No. Right. It can always be better, can never be worse.
Okay.
But bargaining council or the Basic Conditions of Employment Act provides us with a measure of standard. Yeah. We can never go below that standard set by the Basic Conditions of Employment Act.
Thank you.
Yeah.
Thank you, Shane, for the question. All right. Anybody else, ladies and gentlemen? You have an expert here tonight, so give us your case. Yes, sir. Can the employer institute disciplinary action against an employee without first giving the employee an odi patrum altrum patent letter?
No. That is the letter. The letter is the thing that starts the whole procedure. We cannot just tell them you have to be at a disciplinary inquiry tomorrow. We have to provide them with that letter, that notice for them to appear. So no, they can never provide or tell that employee, just tell that employee, listen, you have to be at the disciplinary hearing tomorrow. It has to follow procedure. We have to provide that employee with a notice.
Thank you, Henry. Right, anybody else? Henry, from my side, maybe also there's a question there. Is there cases where, for example, I mean, you've indicated the progressive nature of discipline in the workplace. Is there cases where an employee on a first transgression can be dismissed?
Yes, definitely. It depends on the harshness or the seriousness of the misconduct. So, for example, if it is serious nature of theft, then first offense can be a dismissal. If it is serious abuse, for example, if it is language abuse towards a manager or towards a other employee, discriminatory matters, first offense will always then lead to a disciplinary inquiry that can lead to a dismissal. So definitely there are consequences where, or circumstances where a first offense will lead to a dismissal.
Great. Thank you very much. I have, I've sometimes have experienced that employees kind of get stuck on that progressive discipline and kind of like, doesn't matter if it's serious or not serious, telling the employee, no, you need to go through about 4 or 5 phases before you can dismiss me.
Yes.
Suddenly sometimes get a big surprise when they do something and they get dismissed on the first time. There's sometimes what happens in the workplace. All right, ladies and gentlemen, anybody else there? We have still a minute or two left for any questions. All right, good. And from my side, I would like just to say very thank you. I think, ladies and gentlemen, you will see our speaker is incredibly passionate about his occupation, and I have learned in his previous presentation as well. So I know that he really is living his work. He's not just doing a job to earn a salary. And it's always nice to hear and listen to people that you can hear absolutely have that absolute great passion for what they are doing.
I see there was just another question as well.
What is the remedy if the employer did not follow its own disciplinary code?
So if the employer does not do or follow his own disciplinary code, and it leads to a dismissal at the end of the day, that will constitute an unfair dismissal. And that will be where we talk about substantive and also procedural aspects that need to be proven by the employer at the end of the day. So it will be constitute an unfair dismissal, and the CCMA will make the employer pay at the end of the day.
Thank you very much. And then Raisa, welcome Raisa. Raisa is one of the lecturers there for us, for Labor Relation 100 students there. And she just say thank you as well. And I think this was beneficial to our students. So yes, also thank you for attending the session. I do appreciate. All right, so ladies and gentlemen, I think it is on the dot time there. And I would like to just once again thank our students for attending. And I hope that you have learned quite a bit and a lot of clarity. And I see there's a lot of people applauding you on the side there. Henry, thank you very much for a job well done. I do appreciate your time.
Thank you for the opportunity.
Yeah. And then until we have another chat online and
100%.
So okay, right. Thank you.
Thank you. Have a good night.
Thanks,
bye.
Guys. Have a nice evening, everybody.